Okay, close this party out. All right. Now that you've had your first electronic test, let me get some feedback. How did you guys enjoy? I got some of you commented after the test, but just in general, how do you feel about taking the test online? Was that more enjoyable, less enjoyable, indifferent?
It was nice. It was nice for the essays because I type a lot.
Yep.
The only thing was going back and checking your answers. Sometimes it would get you into like
Okay.
a little slow.
All right.
It's like,
So,
I mean,
so going back and forth was a little problematic, but okay. Well, you should just fly right through it and just not worry about it, right? Anybody else? No? Okay. Well, good. And those of you who took it old style, I will have those graded hopefully sometime next week. That's one of the advantages, of course, of taking it online is that you get your grade instantaneously, except for the essays. All right, today we're going to talk about defamation. We have looked at the intellectual property side of this equation. As I told you when we talked about rights of publicity, rights of privacy is the flip side of that coin. And defamation and slander and libel have a lot to do with the rights of privacy. So before we get to defamation, let's talk a little bit about the rights of privacy. Does anybody know where well, let me rephrase it. Do you know if the Constitution gives us a right of privacy? Does anybody know? Have a lot of bewildered looks. Is there a specific right of privacy in the Constitution? The answer to that question is no. There is no specific right of privacy. In fact, the Constitution itself really has more to do with the operation of the government and applies more to the federal government and its relationship to the state governments than it does to the rights of individuals. So having said that, the Bill of Rights were added later, of course, to accommodate those individual rights and provide us with some rights, and some of which we're all familiar with. If you're looking at the board here, there are a couple that we recognize immediately, right? Article 1. Wait, is this yeah, there we go. What ultimately became the First Amendment was Article 3 of the amendments. These were the original amendments. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for redress. Is that a right of privacy? Is there any privacy inherent in that right? Implicit in that right? When we get together and worship, that gives us this right, doesn't it? Or to assemble. There's a right of privacy implicit in that, isn't there? What about the right to petition the government? Now that's a little bit more remote, but if we're petitioning the government, why are we petitioning the government? Because we have an opinion about something, right? Our opinions go back to our individual selves and therefore go to the right of privacy. So what ultimately became First Amendment gives us a right of privacy. So let's put first up here. Now, what about the second? a well-regulated militia being necessary to the security of a free state. You may not recognize that at first because we haven't gotten to the key words yet, but it gives us the right of the people to keep and bear arms for the purposes of a well-regulated militia. And this says that shall not be infringed. Any privacy in that? Yeah, how?
Well, it's saying basically you're able to bear arms without the government interfering and taking those away from you, so you're allowed to.
So you're allowed to have arms in your home. So that could be a privacy right. So let's put the second up there. What about the third? No soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in a manner to be prescribed by law. Yep, very much so, right? So that's going to be the Third Amendment, or the Third Amendment. So let's move on down. The right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated, and no warrant shall issue but upon probable cause supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In the early days of our colonization, of course, we were still under the British rule, and British soldiers would frequently come in and take over homes. That's why we saw the Third Amendment. And they would conduct searches and seizures at will. So the Fourth Amendment was installed to prevent those kind of things and to give us rights in our own home. Now, obviously, that's very much a privacy thing, and it has become so. And this is probably one of the most obvious amendments to give us that right of privacy. The Supreme Court has taken this to mean that anything within our realm, within our reach as a person, is private, particularly the home, and in some instances the car. So there are various rulings from the Supreme Court that place certain restrictions on police officers from searching a home, from searching a car, and only if it's incident to an arrest or there's certain circumstances. Bless you. So Article 6, which ultimately became the Fourth Amendment, very much so. Now, we can skip over some of these. I mean, we look at the crimes, the criminal prosecutions. Then we get down to what ultimately became, I think, Article 9. And that is Article 11 in the original draft. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. When we talk about the Constitution being fluid, that gets controversial. There are people who would have us believe that the Constitution is written in a time and a place that doesn't apply to today's 21st century standards. However, this clause would argue against that, wouldn't it? Because what it says is just because we've listed a right here in the Bill of Rights in the Constitution, that shouldn't be construed to deny others, other rights retained by the people. Courts have relied heavily on that phraseology to give us certain rights, not the least of which was the right of privacy. Now, I know it's controversial, but Roe versus Wade is one of the cases which gave us a plethora of the rights of privacy. It applied, of course, to the decision to have an abortion, but the rights of privacy have been around before and have been around after and have been enforced in other contexts. But you can see through these amendments how the right of privacy, even though it's not specifically enumerated, is very much a constitutional right. So I wanted to start there before we started talking about defamation. You see on here the words defamation, but you also see the words liable and slander. Those are subsets of defamation, which we'll talk about. You also see the word privacy, because whenever you're talking about libel and slander, you're usually talking about a private individual or a public individual in the context of their private lives. And we have certain rights when it comes to that. So let's talk about defamation. We have the right to be free from people spreading rumors about us, because we have a right to live our lives in privacy in as much as we can. So this saying, a single lie destroys a whole reputation of integrity, is very true. Anyone can bring a lawsuit over anything. Now, there are ultimate issues that can be derived from that lawsuit. There are ultimate penalties for bringing a frivolous lawsuit. But having said that, anybody can bring a lawsuit for anything. So let's say somebody sues me for embezzlement, files a complaint in federal court, and there it is. Local attorney gets sued by client for embezzlement. Is that going to harm my reputation? You better believe it. Is the newspaper in error for reporting that? Well, it reported that a complaint was filed that said I embezzled. That's probably true, isn't it? The complaint is public. The newspaper reporter can go down to the courthouse, look through, and of course if it happens to be a celebrity, that's going to be all the more reason they're going to want to report it. So the thing gets reported. You can't put that back into Pandora's box. If something like that happens to you, it changes your life, usually for the worse. Your reputation gets destroyed, your life gets changed, perhaps your business suffers. So that's why it's important that we have defamation laws regarding libel and slander. What is defamation? We've been talking about it all morning. What does that word mean? What are the roots of the word defamation? Well, it derives from the English word defame, and that literally means to make someone infamous or infamous, to defame them, to take their fame away, to take their reputation away. The English word defame comes from the Latin word diffamare, which roughly means to spread evil reports. One court describing defamation says it means to sully the reputation of another. Now, we don't use that word sully very much. It's an archaic word, and that means to mar, defile, or taint. So you're starting to get the idea. To defame someone means to bring extreme prejudice against them, either by words or by print. And I mentioned earlier, slander and defamation are subsets of slander and libel are subsets of defamation. So to illustrate that point, let me show you a YouTube video. It's kind of a little bit corny, but it illustrates the point of this difference.
Libel is written defamation and slander is spoken defamation. Now, you said this guy called you a car thief. How did he make this statement?
He wrote it in the paper,
In the paper.
the local paper. $1 million, that's what I want. And an apology. I want $1 million and a great big apology.
Let me tell you a little bit about proving a defamation case so you know what you're facing.
Oh, you're facing. I was defamed. In fact, I think I was even libeled a little bit. You said it was in writing.
To prove a defamation case, we must prove that the defendant made a false statement that injured your reputation, that the statement wasn't privileged, and that it was communicated to someone other than you.
Yes, and we have all that. I say we sue.
First things first. You said he called you a car thief. Was this in a letter to the editor, an article, or in an editorial written by someone at the paper?
I don't see how this matters.
As I mentioned, there are some communications that are privileged. Lawmakers, for instance, and judges that sit on the bench can say things in session without being sued with things that might otherwise be defamatory in other situations. If this statement was made in the context of a news report, most reporters know to say something like, police report that Mr. X was arrested for car theft. You know, that kind of thing.
Oh. No, it was not written in an article. It was written in a letter to the editor by Mr. Joe Bishop. So I am going to own his house, his car, and I'm going to have him fired for a vote.
First things first, let's go through this point by point. What did Mr. Bishop say?
I knew you were going to ask that. And because I knew you were going to ask that, I brought a copy of the article. Give it a read.
Let me see. Well, it does mention you by name. Let's see. It also says that you are a car thief.
Ah, seen enough. You know, I'm kind of thinking at this point that $1 million might not be enough. You want to go for $2?
There's something else in here that bothers me.
And what's that?
It says here that you have been convicted of stealing cars. Is that true?
I did plead guilty to car theft a couple of years ago. But that was a couple of years ago. It's been a while since I've really looked at a car.
Well, you might remember what I said, that defamation is a statement
Yeah.
about you
Yeah.
that injured your reputation.
Yeah.
But the statement also has to be false.
What?
This statement is true, so it isn't defamation.
It's not even slander.
It's not any kind of defamation. You pled guilty to car theft, and I'm afraid that makes you a car thief.
I would watch your step, miss. Because I might get you for slander. Good day.
Yay.
So you kind of get the point of defamation and the difference between slander and libel. So let's go over some of these distinctions. The fundamental difference, as she pointed out, between libel and slander is how the defamatory statement is published. As she pointed out, verba, volant, scripta, manent. What does that mean? Well, that means spoken words fly away, written words remain. How does that apply to defamation? Well, slander cases, as she said, deals with the spoken word. Libel cases deal with the written word. Therefore, as you might imagine, libel carries more consequences than slander. It is also easier to prove, since written words are there in print, whether they be digital or physical. Spoken words, as it says, fly away. Therefore, spoken words are harder to prove. They very frequently become cases of he said, she said. So the courts look a little bit more prejudiced on a slander case than they would on a libel case. So, how do you slander someone? With a word. There have been slander cases involving sounds. There have been sign language cases, gestures. There have even been cases of signs people hold up in protest of a company. So, as you might imagine, this also sometimes implicates our First Amendment rights. Do I have a right, if I buy a lemon of a car, to go down and stand across the street from, let's say, Thoroughbred Motors and say, don't buy a car from Thoroughbred, I got a lemon. I might have that right if that statement is true and I can prove it. If the statement is false, it could hurt their business and I could be charged with slander. So you can do that any way. For example, Rebecca tells Patricia that I am a fraud, and then Patricia refuses to do business with me because of that statement that Rebecca made. That's slanderous if it's untrue. Therefore, I sue Rebecca, and I prove that I have lost business because of what Rebecca told Patricia. Rebecca would have to pay me for my loss of business, whatever the value of that becomes. However, she doesn't have to pay me for the general damage that may have caused. If Patricia tells somebody else, that person tells somebody else, that's going to hurt my business. There's nothing I can do about that. I have to prove specific damages because defamation falls under what we call a tort law. And to prove a tort, there has to be a standard. The standard is you can't go around making false statements about someone. There has to be a breach of that standard. And there has to be damages flowing from that breach of the standard. It all goes back and is very closely logically tied together. So if the damages result from the breach, then I have a tort case. All torts are that way. There's some standard involved, there's some breach involved, there are damages. Take a malpractice case. There's a standard of surgery. A reasonable person has a reasonable expectation that a surgeon knows what he's doing and won't leave his or her earring in the cavity when it's open. That happens, I get an infection, I have damages that result from that. It costs me $100,000 to get my infection cured, find the earring and get it removed. Those are specific damages relating to the breach of the reasonable man standard for malpractice. So the tort standard applies in defamation cases. But as I said, most slander cases never really reach the court. Why? Because they are difficult to prove. Anytime you get into an arena where you're talking about spoken words, all you have is testimony. And any criminal attorney will tell you testimony is probably one of the most unreliable types of evidence that you can have because memory differs. If all of us are standing on the corner out here enjoying this beautiful day and we see a car accident, I bet we would have 3 different testimonies about the color of the cars involved. Because your red may be my maroon, maybe JT's pink. We're all going to describe it differently. And the jury has to assemble from all of those different bits of testimony what the truth is. And hence the unreliability. Now, libel, on the other hand, is published. It is something that is written down somehow. It can be published in a newspaper, but it can also be in film, moving images, television. It can be in cartoons. It can be on the internet. It can be in the form of a sign. There can be all kinds of different ways you write something down. Perhaps you write a letter or an email to someone. Those are all libel. Libel cases, as I said earlier, are treated by the courts as more serious than slander cases because of that permanent nature of the written word. There are 4 circumstances in which a jurisdiction might look at slander a little bit more seriously. And that is if someone accuses you of a crime when you haven't committed it. The court will look at that and take it very seriously. If you have been accused of having a contagious disease, the courts will take that seriously. Someone makes a negative remark about you in your workplace environment. Or finally, someone accuses you of having committed adultery. Those are all circumstances where courts have looked at slander and have said, yes, this is serious enough. There's enough evidence here. I'm going to award damages. But generally speaking, liable, far more powerful than standard because of that Latin phrase. The written word has permanence. Therefore, it has the power to do a lot more harm than slander in most cases. So you heard the key elements. Here they are again. Key elements are: the defendant published a false statement. Published is a term of art that we'll look at in a second. It can be published either through slander or through libel. The statement is about the plaintiff. You heard her mention that the article specifically said his name. That's very important, and I'll tell you why in a minute. Finally, the plaintiff has to suffer actual damages. This gets back to my tort analogy. And those damages have to be the proximate cause of the statement. That gets back to the relationship to the breach. Proximate cause, if you go to law school, you'll become very familiar with that concept. But it has to be logically related to the breach. So in the case of our surgeon, there's a standard. He has to perform surgery according to a reasonable standard. The medical profession, the AMA, he breaches that standard by leaving his earring in the cavity of the recipient of the surgery. That person is damaged, has to get that repaired. That is the direct cause, isn't it? Not just proximate, but direct. Direct, a little bit higher standard. So all related. Same thing with libel. If I have suffered damages, like my analogy of Patricia and Rebecca, Patricia won't do business with me because of what Rebecca says. That's a direct cause of loss of business. If I would normally get somewhere around $5,000 to $10,000 in fees from that, I can prove that. This is the type of case she had. This is how many damages I had. This is the proximate cause of the loss of my damages. Therefore, I'm entitled to that much as a result of her slander. So you kind of see how it works. Now, I mentioned publication as a term of art. It means simply that you communicate that to a third person. So communicating it to a third person, but it means a little bit more than that. That person, the person to whom it communicates, has to understand that it refers to the plaintiff. Now, what does that mean? If I'm on a blog and I'm talking about a hacker by his code name by which he goes on the blog, and I slander him by saying that he is a hack, and the person who hears that understands that to be a compliment. Someone who hacks is a hacker. They're good. They perform good things. They don't understand it to be a bad thing. And they don't understand it to be about the plaintiff. So two things wrong there. First of all, they don't understand it in the negative context. And second of all, they don't understand it to refer to the plaintiff. So publication is a term of art, which means it's communicated to someone and that person understands that it refers to the plaintiff. And that gets back into our proximate cause. The restatement of tort is where we go to derive these standards. And in that statement of defamation, there are two applications. One is to a private person, and one is to a public official. Now, the public official will be treated differently when they are operating in their public capacity. If they're operating in their private lives, they should be treated in the same context as a private individual. So there are two standards for that. So let's look at them. For a public person, the Restatement of Torts says this: defamation is defined as one who publishes a false and defamatory communication concerning a public official or figure in regard to his conduct, fitness, or role in the capacity, and they're subject to liability if that person making the statement knows the statement to be false and that it defames the person, or acts in reckless disregard to those matters. In other words, he doesn't really care whether it's true or not. He acts in reckless disregard. So that's the application to an official acting in their official capacity. Now let's look at the one for a private individual. One who publishes a false and defamatory communication concerning a private person or concerning a public official or figure in relation to a purely private matter not affecting his conduct. And that person would be subject to liability if they know the statement to be false and that it defames the other person, same as before. Acts in reckless disregard of those matters, or acts negligently in failing to ascertain them. The negligence standard that's added here is a lesser standard. I should have made an effort to investigate and find out if the statement is true before I pass it on. That applies in the situation of a private individual or a public official acting in a private matter. And that's the difference. That additional requirement or that difference was really established in the case of New York Times versus Sullivan. We refer to it as actual malice. In other words, the person making the statement about a public official only defames if they're acting out of malice when they make the statement. In other words, it's their intent to harm that individual. So that's a pretty big standard, and that's a pretty big difference. When you're talking about a private individual, you're only talking about negligence. I failed to ascertain whether it was true or not. Here, the Supreme Court turns it around and says it has to be actual malice. This happened as a result of a very important, very prominent case. The New York Times carried a full-page ad entitled "Heed Their Rising Voices." The purpose was to solicit funds for the defense of Martin Luther King, who had been indicted for perjury by an Alabama court. This was, of course, during the racial riots of the 60s. L.B. Sullivan, seen here, was responsible for the supervision of the Alabama State Police, the ones who had arrested Martin Luther King. Certain statements were made in the publication of that ad which were incorrect, inaccurate. Sullivan was rewarded, that should be, comma should be there, that's $50,000 by an Alabama court when he sued for libel. However, the case went up to the Supreme Court. The Warren Court ruled that the standard elements of defamation applied by the Alabama court, the elements applied to a public official acting in a private matter, the negligence standard, did not protect the First Amendment rights of free speech and the freedom of the press. They said in order to safeguard those rights, a public official suing for defamation must prove that the statement in question was made with actual malice. Did the New York Times intend to hurt Sullivan by placing that ad in the New York Times? No, they didn't, according to the court. So therefore, actual malice was added as a requirement. And that refers to reckless lack of investigation rather than the actual malice. Celebrities are generally treated for this purpose as public officials. We have greater leeway as to what we can say about David Letterman, Jay Leno, people who are in a public capacity. actual malice may be required if they were to sue for defamation or libel. This also applies in certain circumstances to private citizens. If they have inserted themselves into the public dialogue, and we all know examples of this. You may remember back in the, I think it was the first election of Barack Obama, a certain individual in Ohio who came forward, asked a question. Who was he? You guys remember? Anybody in politics here? Joe the plumber. You guys remember Joe the plumber? Well, Joe inserted himself into the public dialogue. As a result of that one question, he became a celebrity. He became well known. So if we were to defame him, if a paper were to publish an article about him, he would likely have to prove actual malice as well, because he has inserted himself into the public dialogue. That's what we call a limited public figure, one that deliberately engages in actions that generate publicity within some narrow scope of interest. Joe the plumber asked a question of Barack Obama, knowing full well that it was televised, knowing full well that it was a controversial question, knowing full well that it would be reported. So in doing so, he deliberately engaged in an action that generated publicity within the field of politics. An example, a woman named Terry Ricolta was offended by a Fox television show, Married with Children. She wrote letters to the show's advertisers saying, you should stop funding that show because it is this, that, and the other thing. That attracted a lot of media attention. By writing those letters, she inserted herself into the public dialogue. So she became the target of jokes. David Letterman, Jay Leno. But these jokes remained within the confines of her public conduct. They were not intended to be malicious. So when she sued for slander or for libel, because this was a television broadcast, the court said, no, you're a limited public official. Therefore, you have to show that David Letterman actually intended to malign you. He intended to cause you harm. Therefore, she lost that case. So you start to see how the courts apply these standards. Another way you can be held to a different standard, to the higher standard, is if you become an involuntary public official. We have the limited public official. We have the involuntary public official. If you are arrested for a crime, you are deemed an involuntary public official, and somebody can talk about you as a criminal. They can print things about you as a criminal, much like you saw in the vignette. He was a car thief. He was arrested as a car thief. Therefore, the person writing to the editor had every right to refer to him as a car thief. Not only because it's true, but because he was an involuntary public official. So, even if innocence is established, any action for defamation would be difficult to prove on the basis that the notoriety associated with the case and the accusations against them are made in the context of their public official capacity. All of this becomes much more serious when you think about our lives today. When you think about Facebook, Twitter, YouTube, etc., etc. Everybody in this room, I can see, has a smartphone. That smartphone is capable of recording something instantly, isn't it? Just ask Michael Richards. Everybody knows Michael from Seinfeld as Kramer. A couple of years ago, he made some insensitive remarks, very insensitive, very politically incorrect, in a nightclub. Someone was filming it. He didn't know they were filming it. He was acting as a public official in a limited public capacity. There was no actual malice in the filming of that. In fact, they were probably doing it because they liked Michael Richards. That gets up on the internet. Is that slander, libel? No, it's true. However, we have to be careful when we're talking about tweets, when we're talking about Facebook, because it's all about somebody else, right? In fact, on Facebook, you can like something, can't you? One teenager I know, in a circle of friends, was talking about one of their classmates. They were talking about what a major female dog she was, right? Not very kind, I admit, but they were on Facebook. They assumed they were talking among friends. The one teenager hits like. He doesn't comment on the statement that was made by someone else, third party. He just hits like. Is that defamation? Is that libel? It's in writing, right? It's about a third party. It's being communicated. You're saying you like the fact that he's calling her a bitch. Now, parents got involved. Situation escalated a little bit. That one was resolved. But had it gone a step further, that could be a case of libel. So we have to be careful in our environment because we are creating new ways of defamation. And that doesn't change the law. The law still says there's a standard. If you breach that standard and causes damages, you are liable. So we have to be careful. I had another video there. It's not working. So what are the remedies? The law of damages. What kinds of damages can you get from defamation? Well, in order to prove damages, and the plaintiff in these cases has to prove damages because that's part of the tort. You have to have clear and convincing evidence. We all know what that is from a previous lecture. Very high standard. You have to have clear and convincing evidence of impairment of reputation, impairment of standing in the community, personal humiliation, or mental anguish and suffering. Now, I will say this, the latter category, mental anguish and suffering, extremely difficult to build a case around if that's your only proof of damages. Courts are very reluctant to give someone damages because they've lost sleep for 2 weeks, right? Or because they have cried themselves to sleep for 2 weeks. Yes, we're all sympathetic, but when you're talking about damages, courts want something a little bit more. Everybody's going to be hurt when somebody says something about them. We have to take account for the fact that there are people who will be more hurt, so we have to take account for that. So there has to be something more, and that's where the impairment of reputation or standing in the community comes in. So if you have all of these things, you're much better off improving damages. So what kind of damages can we get? I've seen all three of these in libel cases. Most of them, some of them in slander cases. Actual damages you can always get. Like in the case of the surgeon, if you can make a proximate cause case that your damages are real and that they came from that statement, that's a connection that you can build and your actual damages are recoverable. Sometimes you can get special damages. What's that? Well, if I'm slandered in the way I talked about very early on, I'm sued for embezzlement by a client, that case gets thrown out, the paper reported it incorrectly, I could sue the paper. I might get damages not only for my loss of business directly, but for my general reputation lost. Let's say I was earning $500,000 a year in the years leading up to that case, and it dropped down to $100,000 a year the year after. Now, there could be a number of factors going into there, but let's say we can tie it to that one statement. That's a $400,000 loss, right? Next year I only earn $200,000. It takes me 3 years to build up, and I can prove that. Then I've got a case for hundreds of thousands of dollars of special damages. And then finally, there can be punitive damages. Depending upon how egregious a statement is, how much actual malice or intent was involved, a court might allow a number, let's say $1 million, like the kid wanted in the video, for punitive damages. In other words, trying to punish the person and say, you really did a bad thing here. That's punitive damage. And to get those, you do have to have malice. So that's the caveat with that. What are the defenses to defamation? Well, of course, truth is an absolute defense, because one of the elements is it has to be a false statement. So truth, an absolute defense. If you can prove that it's true, no problem. Certain people have an absolute privilege, which you heard her say in the video. For example, statements made by witnesses or lawyers in a court of law are privileged statements. Most of those are defamatory in some way, but they're made in the context of a court hearing. We want people to testify in court, so we give them immunity. The lawyers, the judges, all of those are privileged in a defamation suit. Also, if the legislatures are standing up, making statements on the floor, they are immune from defamation. This explains, if you've ever watched C-SPAN and seen all the Republicans talking about all the Democrats, or all the Democrats talking about all the Republicans, they don't use words that are really friendly. In fact, I've seen some pretty harsh statements said on the court. I'm almost embarrassed to be a citizen sometimes with the statements that they make. But the reason they do that is because they are protected from defamation. I can say anything on the floor of the legislature. True or not, I'm protected because there's an absolute defense. So it's absolute, meaning it doesn't matter how much malice is involved. It doesn't matter if it's a gross lie. Someone cannot sue you if you are a senator or a congressman making a statement that Joe Smith committed adultery with his intern. True or not, doesn't matter. Can't be sued for that. Those people have absolute privileges. Certain people have qualified privileges. For example, news reporters, they are qualified. They have some qualified immunity. So you can get over it, but you have to prove that actual malice, and that's where that element comes in. A citizen has a right to make a fair comment. That's where First Amendment intercedes defamation law. So I can make a comment about opinion, and if it happens to be slanderous somehow or libelous somehow, I might have a qualified immunity under the First Amendment. Finally, innocent dissemination by a postal worker or by a blogger might be a qualified immunity. I used the example of Facebook and hitting the like. That could be dissemination, and it could be a qualified immunity. So with that, I will end the lecture on defamation. Please keep an eye out on your email. I will be out either Friday or next Wednesday, either on the front end or the tail end of the break. We don't have class Monday. So keep an eye out tomorrow for an email from me notifying you whether you need to be here Friday or not. Okay? All right, thank you very much. You guys have a good day.